Samantha bought a home. This is for Lee Harris over at Limestone. She bought a home pretty much sight unseen earlier this year and now needs to sell it. She's worried because the home is in need of a lot of repairs. The sellers may have kept material defects off the disclosure. So we want to review what the material defects are. And then she says on top of it all, the loan was a VA loan, in addition to the inspection report, which was substandard. The VA inspector / appraiser, they do some inspections, should have caught and flagged some of the problems that she's discovered over the course of the past months. So she's wondering, does she have any recourse going back against the seller for maybe not disclosing properly? Lee?
Yes. So under Kentucky law, a seller is required to disclose any latent defects in the property. So a latent defect, it's different than a patent defect. A patent defect would be, for example, if you walked into a living room and there was a big hole in the wall where somebody had maybe punched a hole in the wall. Okay, we can all see it. That's a defect, but it's one we can all see. A latent defect is something that a person who doesn't live there might not know about, something that's been fixed that I can't see, or something that's been broken that the seller knows about that the buyer doesn't know about. A home inspection is sort of supposed to fill in that gap to some degree to find those latent defects so that then the buyer and seller can negotiate about repairs. However, if it can be proven that there is a knowledge on the seller's part and they did not complete the the disclosure correctly, then they do have liability, because the seller disclosure form is a sort of a piece of evidence for the buyer as to what the seller acknowledged in writing was wrong with and correct with the property when they purchased it, and they're allowed to rely upon that.
All right, we'll follow that in a second, but let me ask this, Lee. If there was a piece of furniture in front of a hole or holes in the house, it wasn't visible when the inspector was there or when the buyers were there, would that fall under the category of latent since they were deliberately hiding the hole?
Yes. If someone is trying to deliberately hide something, a lot of times you'll hear there was a crack in the basement foundation, but there was a whole lot of boxes there when the inspector got there and they couldn't get behind them. And then, of course, when the seller moves and takes the boxes away, it's clear that was there as sort of a shield so that the inspector and the buyer wouldn't see that. So yes, if there's some kind of proof that they were trying to hide a latent defect, they didn't disclose a latent defect, they had been advised that it needed to be fixed and they didn't include that on their form. There's a lot of different ways where a buyer can form a nexus between the failure to disclose and the seller's knowledge.
So what's their next step then? What would any of the people who are listening now who think there's a problem here, what is their next step?
I advise people to do it this way. Under your Louisville contract, if you're in Louisville, you have a mediation / arbitration provision, which keeps you, for the most part, out of court. Anything that is up to $2,500, which is small claims, you can still go to small claims. Anything that's more of a major defect, usually it's HVAC, roof, basement, those type of things are obviously usually more than $2,500. I suggest that the buyer gets some estimates from some professionals, figure out exactly what it's going to cost. If it's above that small claims threshold, then draft a letter, ask their agent to send it to the seller's agent, trying to explain what they found, explain the discrepancies between that finding and the seller disclosure form, ask them, here's my estimates, I'd like to resolve this amicably. If not, we can go to mediation arbitration. And mediation is a process where the people try to work it out themselves. They pay a small fee to a mediator who is there as a neutral to try to facilitate a negotiation between the buyer and seller. If that doesn't work, then it goes to arbitration, and arbitration is a little more expensive, a little more formal. There's an arbitrator there, and that arbitrator listens to facts and listens to testimony and looks at documents and all of this kind of thing and determines who's right and who's wrong. And you win or you lose, and it's binding. There's no appealing an arbitration award. So if it's something that's worth going after dollar-wise, then you could try the mediation / arbitration route. Got it.
Incidentally, folks, if you want to hear or see a replay of this show, if you've got some facts that you want to listen to again, go to LouisvilleAnswers.com. That's a video replay on our YouTube channel, LouisvilleAnswers.com.